So the best or the worst thing about FAMA, in my personal view, I have been sort of practicing it for last about 2 decades, is that this is a law which doesn't speak, which is silent. It is more the regulation, which is now being coupled with the different practices being followed by different AD bankers and different professionals. Ultimately, everyone has his or her view. So with due respect, I think I would be discussing my thought process in terms of regulation, also the practical challenges, case study which we have come across, trying to wind up in next about 20-25 minutes given the time constraint. So here we go. Now first part is going to be on the side of downstream investment. So downstream investment basically is the indirect foreign direct investment. So what happens when a foreign investor coming to India and investing into a company directly by way of subscriptions or otherwise secondary purchase, he is purchasing from an existing shareholder, be resident or non-resident. That's a direct investment or foreign direct investment. You all know the concept FDI or downstream. It is in the equity or quasi equity, means equity capital or a mandatorily fully convertible equity capital, which is CCD, CCPS or warrant. We read the word share warrant, but let me tell you, and I will be sharing some thought, some practical issues. There is no concept like share warrant. We like it share warrant, but generally it is a warrant which is convertible into equity share. Why I am saying there is no concept like share warrant? Again, I would refer to the mother law, section 114 and 115 of the Companies Act 56, which have been omitted. So share warrant used to be a concept which is actually issued in lieu of fully paid up shares. That is actually the concept of share warrant. We use it loosely, but when it's a share warrant, it is a warrant which is 100% mandatorily convertible into equity shares. So that's a equity instrument. So what is the what is the meaning of downstream investment? DI, downstream investment, means an investment made by an Indian entity, which has a total foreign investment in it into any other Indian entity. So the company which is making investment is a company called FOCC. So for example, there is a company A which is foreign owned or controlled. So company A is an Indian company which is known as a FOCC, foreign owned or controlled company. So if this FOCC is making further investment into the equity instrument of any other company, Indian company, so that investment is known as a downstream investment. That's the concept of DII. So that's how these two conditions, if you see indirect foreign investment, so on the left, on the right we are talking about the pool investment. So on the left it's a generic kind of investment entity, Indian company which has received foreign investment. That's a condition number one. And the second one is that this company should not be owned and controlled by PRI, which is person resident on India. Otherwise we can say this company should either be owned or controlled by a person resident outside India. So here I would like to draw a line of a kind of emphasis on the concept control. Generally we talk about more than 50% it is owned or controlled, but I think the concept control we should also be mindful about. I tell you why, because the kind of regulatory framework now we guys are dealing with, right? The control is a very inclusive yet dynamic term. Same definition under the RBI regulation, under the Companies Act, under the RBI, under SEBI, under CCI. So the very crux of control is that either you have a right to appoint, remove the majority of director, which is very, very obvious. The second is very critical and subjective. If a person has a right to control the management policy, we call it a negative control, that is amounted as control. So if a foreign investor in your company may be having about 10%, so you are not a FOCC because of 10%, but if that person has that driving force, if he has a negative control, he can drive your policies, management. So probably you would be a FOCC, even if the investment of FDI is less than 10%. So that's very subjective, but we have to be mindful about that thing. So that's the concept of FOCC at the first go. So here are the illustrations. So in the first, a foreign companies has made about 40% capital investment in ABC, which is Indian company, and the ABC would have made 100% capital investment into XYZ. So here ABC is not a FOCC because in ABC foreign company holding is less than 50%. So ABC is not owned by foreign investor, and I'm assuming that there is no aspect of control. So I'm assuming it. So then ABC is neither owned nor controlled by foreign Inc. In that way, ABC is not a FOCC. Because ABC is not a FOCC, then any investment by ABC into XYZ, even if 100%, will not qualify as direct investment. Second example, because ABC is more than 50% owned by foreign companies, so ABC would be regarded as FOCC. So any investment by this ABC into into XYZ, it would be DII. So this investment of 30% is less than the investment received by ABC from foreign Inc. So the entire 30% would be treated as DI, which is downstream investment. Case number 3, if you see, again ABC would be FOCC because it is more than 50% owned by foreign Inc. and ABC in turn has floated a 100% subsidiary. So this 100% investment made by ABC would not be termed as DI. It is only to the extent of FDI received from parent company, that is 80%. So the 80% would be considered as downstream investment by ABC. Any company which in these three kind of illustration is ABC, which is FOCC, has having made this DI downstream investment, they have to file from DI electronically on the web portal. That's a one-time reporting. So why I think the concept is same, but the idea is that DII can go to any level. So here I have created one more sort of layer of QPR. So idea to show you that DII may not be only at the first level, it can go to second level, it can go to 3 level, it can go to 4 level. It's a factual thing. But here again we have to be mindful about the per se restriction under the Companies Act. A company cannot have more than 2 layers of subsidiary except as prescribed for certain class of companies like banking, insurance. So that's the basic about the kind of structuring we have to be mindful about. Secondly, under FAMA also, if you are doing some investment outside India, that in turn money is coming back, that's known as round tripping. So now good part is that they have sort of allowed that kind of round tripping, but with some restrictions again, going back to the Companies Act. So in this case again, if you see in the first case, it is the downstream investment. So ABC is again a FOCC because it is owned controlled by foreign company by more than 50%. So any investment by ABC into XYZ is a downstream investment. Again, XYZ becomes a foreign owned or controlled FOCC. So investment by XYZ into QPR, which is 80%. That would be downstream investment. Even if XYZ has created 100%, but because in XYZ itself the downstream is only up to 80%, so only 80% would qualify as DI, downstream investment. Again, in the second leg, there is no downstream investment in QPR. Reason being, XYZ itself is not a FOCC. ABC. So again, ABC is basically a FOCC. Now ABC has made downstream investment into XYZ, so this 30% is downstream, but XYZ is not a FOCC because in XYZ the investment is less than 50%, so there is no DI in QPR. Now the last slide, again foreign company has made 80%, so ABC basically is a FOCC more than 50%. Now ABC has made 70% in XYZ, so this 70% basically is DI, which is downstream investment in XYZ by ABC. Now XYZ in turn has made 100% in QPR. So the downstream investment size in QPR would be 80% of 70%, that is 56%. So that's a pure mathematics. Just let me share the third illustration. Let's say third illustration, they say ABC has floated 100% subsidiary, right? So I am saying this 80% investment in XYZ would be direct investment. Let me quote the rule. So what rules say? Rules say that, this is rule number 23.3. This reads as under: indirect foreign investment received by a wholly owned subsidiary company, quote unquote, wholly owned subsidiary company. Indirect foreign investment received by a wholly owned subsidiary company of an Indian company, which is ABC here, shall be limited to the extent of foreign investment received by the company making downstream investment, which is 80%. So why I say wholly owned subsidiary? So I'm just putting it differently. Let's say if as against XYZ it would have been a LLP. If as against XYZ in this case it would have been a LLP, XYZ LLP. whether we would have qualified this as a 100% as a downstream investment or not. Because law says that investment received by wholly owned subsidiary. So the basic question comes here, can a LLP be considered as a subsidiary company or not? Going to the Companies Act. Companies Act says that company for the purpose of subsidiary or holding, subsidiary or holding in the context of company would include body corporate. LLP is a body corporate. You know that. So if you read the definition of subsidiary holding, which includes body corporate, LLP is a body corporate. Whether a LLP be considered as a subsidiary or not. Because you guys know better than me. Because if you say yes, then ABC would have been subject to mandatory consolidation of accounts of that LLP. It's a subsidiary. So you guys know better than me about the LLP and the consolidation vis-a-vis subsidiary. So what is your thought about it? Sometimes, logically, legally it is, logically it may not. So the answer would be no. LLP cannot be constituted as a subsidiary, because the very opening part of the definitions of holding of the Companies Act or any act, they start with a very powerful expression. They say, unless the context provide otherwise. So if you read the whole structure of the Companies Act and whole structure of LLP, so the context may not fit within the Companies Act. So LLP cannot be constituted as a subsidiary, because if you constitute it as a subsidiary, so there would be a drastic interpretations issue, not only under the Companies Act but also under other laws, be it FEMA, income tax, LLP. So while the LLP cannot be considered as a subsidiary, however, I would say still this 100% made by ABC into this should qualify as a direct, as a downstream investment, because the essence here is that of the foreign direct investment coming up in an eligible entity. And the opening part I have mentioned that, if you see in the opening part I mentioned that the first line, the first bullet, I would say the fourth line, capital instrument or the capital as the case may be of another Indian entity. So Indian entity includes company as well as LLP. So the capital has been used with reference to a LLP. So that should qualify as a downstream investment, although the rule refers only to a wholly owned subsidiary. So it's a classic case of Vodafone actually. It's a Vodafone matter only actually. So I have been fortunate working with the Vodafone, and that issue came up immediately prior to the merger of Vodafone into Idea. Almost everyone sitting in this room know that Vodafone got merged into Idea, but very few would have known that within the Vodafone there was a complex structure which they inherited from Hutch people. So in the Vodafone there was about 13-15 kind of shareholder entity, Indian and the overseas, with a cross shareholding, and there was a merger actually happening within the Vodafone. Company 1 into company 2, shareholder company 1 into shareholder company 2, shareholder 2 number shareholder 3. Though there was a scheme of merger within the Vodafone India Limited, wherein they were trying to achieve a simplified structure. In one scheme, we contemplated about 12 merger, and that company was being merged into Idea. So that is a shareholding pattern of Vodafone. What happened? This company, this overseas entity, Mauritius, it was holding 49% stake in this company, Scorpio Beverages, and rest 51% being held by Indian shareholder. So it was clearly not a case of FOCC. Again, the emphasis here is that Scorpio, the Mauritius entity should not have any control. If they have a control, then it may be FOCC assumption, and it was not a control. So it was a normal company, Indian company, domestic company, and this company floated 100% subsidiary into healthcare, and in turn that company floated a 100% investment advisory company, which is Andy Callis. So what happened subsequently, this Mauritius entity acquired the remaining 51% stake from the Indian shareholder. So this Scorpio became FOCC, in turn MV Healthcare became FOCC, in turn this last company, which is Andy Callis Investment Advisory, became a FOCC company requiring government approval, because that sector, investment advisory, other financial services, as on date, earlier it was a kind of investment company, they were subject to government approval, which is still the case. I will cover it in my other slide. So they failed to obtain the government approval. They had no clue about that we have become FOCC. So this matter went to the RBI, and they imposed a penalty about I think 90 lakh rupees something, and this matter got compounded. So the idea is that FOCC, to be the status of FOCC should be checked not only at the time of investment but also subsequent share transfer. That kind of compliance should have been done. Ideally, the MV Healthcare and the Scorpio should have also filed from DI, because now they have become the FOCC. So why I'm, okay, just high level thought about control, and I will cite only one illustration. As I said, control is very subjective. The best defense against any special right which may be construed as control is that you always claim that this is not a control, these are not the active rights, rather these are the minority protection to me, these are the passive rights. For example, and it's all is in the drafting, if investor is writing in the definitive agreement or the article saying that target company cannot do any related party transactions except my approval, it is aggressive. Target company cannot do any borrowing except my approval, it is aggressive, right? One can say you are very much affecting day-to-day right, so which is means you are in control. So rather than putting in this way, you should give some carve out. What you should have written ideally, the target company may not enter into a transaction of borrowing more than 20% of its turnover, some threshold. A target company may not appoint a person beyond a KMP position. A target company should not do a related party transactions amount, and that is by large a accepted industrial process, I would say, position. The last case on control was in Subcom Ventures, which went to appeal till Supreme Court in 2010. Supreme Court rejected the petition, because by that time Supreme Court could have come to decide the petitions. So the investor took a kind of exit from the company by way of mutual settlement, and Supreme Court very categorically disposed of the petition, saying that we are disposing of the petitions, and this precedent should not be this order should not be considered as a precedent going forward for the purpose of deciding what right may not amount as control. So that is the landmark case, happened on the SEBI versus SET matter. But that's the case which I think one should be mindful about. This is very, very important and practical. I'm sure this would excite many of you being chartered accountant. So one of the conditions for downstream investment is that if you are a downstream investment, if you are a FOCC, any investment by you in any company would be considered as a FOCC. So one of the important conditions is that the funding which you will bring, the funding which you are going to put in the target entity should either be raised from abroad or it should be by way of internal accrual. You will not raise fund borrowing from the domestic market. So you will not do any borrowing from the domestic market, either go to the parent or abroad, or you can, if you have an internal accrual, means the profit transferred to general reserves, that's the definition of internal accrual. You can use only these two things. You can't borrow from the domestic market. Unfortunately, the term borrowing, the domestic market is not kind of clarified. We all know borrowing, what is the borrowing, but what would constitute domestic market? So that's a matter of interpretation. Now in this first case, if you see illustration number 1, this is a live case, in fact, which has happened about a year back. I may not name the client. There would have been 10 more, I would say. It's a foreign company which has a FOCC in India, means let's say which has about 80% stake in this company, and this FOCC is now going to acquire a target 100% share purchase from the promoter. But this FOCC does not have profit. This company is into losses, so there is no question of internal accrual. And the parent company, let's say, is subject to PN3 note, because the parent company comes from a jurisdiction which is sharing the land border, right? So the FOCC cannot raise money because it will go to kind of government approval route. So it has to raise money from sort of abroad, but there is no source available. Now what can they do? The third option is that internal accrual. They do not have internal accrual. So what can they? What option they have? So they have to go and raise money from the domestic. They have to raise money from the abroad, which is not the option available. And the restriction is that they can't borrow money from the domestic market. So if they go and kind of approach any financial institutions or banks, probably that may get caught within the meaning of domestic market. Obviously, bankers and financial institutions, they would constitute domestic market. Interestingly, what they are doing here is that they are entering into a short-term arrangement with their sister concern of FOCC, which is a subsidiary of a common parent kind of group company. So that sister concern of FOCC is providing a short-term funding to them, maybe for next 6 months on arm's length basis, and that money is being used for the purpose of this acquisition. So this short-term arrangement is a privately entered into arrangement for which they have not entered or they have not approached the market, the financial institution or the bankers. So that is a case which may not amount to accessing to the domestic market. So I hope me and you are on the same page, because the term domestic market is not clarified. So it's a matter of interpretation. It's a kind of risk appetite you have to kind of take while taking a call. Second case. Now, sir, coming to the second one. So this is swap of shares. This case is swap of shares. So here the FOCC is making investment, but not by way of any internal accrual or by way of raising fund from abroad. It's a swap of shares happening. So what is happening is a foreign company which has a FOCC in India, and this FOCC has, so what is happening in the Indian company, there are some other existing shareholder. So this company FOCC, they are acquiring shares of this Indian company. So this FOCC, what is happening in this case, this FOCC company is acquiring shares from Indian company from the existing shareholder. And as against consideration, they are not making any payment, they are issuing their own shares to the existing shareholder. So it's the acquisition of shares in Indian company by FOCC for consideration other than cash. So the crux of this kind of illustration is that this is also allowed even if there is no kind of sharing of consideration in cash. So these are the reporting requirement. If you see, FOCC is transferring its investment to a person resident outside India. So whether the repeat pricing is required, no, but FCT has to be filed, because FOCC in any case is an Indian company, so transfer happening between FOCC, which is put at par with resident, to a non-resident, so FCTS is required, and this is coming purely from the RBI master directions. Second, FOCC is transferring shares to a PRI. Here the situation is reverse. Pricing is yes, but the reporting is not. Third is FOCC to FOCC, neither pricing nor reporting. This is again a pricing requirement, this master direction. So master direction has spoken about when FOCC is selling to PROI, or FOCC is acquiring from or selling to PRI, or FOCC is selling to FOCC. But there is no mentioning about FOCC acquiring from PRI or FOCC acquiring from PROI. So law is silent. There is no stipulation about it in the, again, the master direction. But practically speaking, these AD bank have been requesting you should go and adhere to the kind of pricing and the FCTRS. So this is the last aspect about FOCC. So as I said in the beginning, FOCC can make investment into the equity or the quasi-equity, which is mandatorily convertible. Question comes whether an investment by a FOC into optionally convertible share, OCPS, optionally convertible debentures, optionally convertible preference shares, whether you can make such investment or not, whether that is permitted, prohibited, allowed, what is the position. Again, the law is purely silent about it. Right, the one school of thought says that it's a capital account transaction. So generally saying about capital account transactions, if it is not permitted, it is prohibited. Same way, what you say that you can't do directly, can't do indirectly. At the same time, there is no prohibition. But I tell you, practically speaking, people don't do this kind of investment for the simple reason is that I'm making investment into optionally convertible preference shares, which by the way doesn't amount to ECB, because ECB is something when the entity raising fund is the direct entity. So means the borrowing company is a company which is raising fund directly from the investor. So it is certainly outside the purview of ECB. But I tell you practically why they don't invest in OCD, because it's a sizable amount of investment, and the issue again comes not from FAMA but from the provisions of the Corporate Law, Companies Act, because something goes wrong with the company, vis-a-vis wrongdoing on the management. So the provisions concerning operation mismanagement, do not suit the investor, because they are holding, OCPS, OCD, which is not a quasi-equity instrument. So they may not be regarded as a shareholder, per se. And that's the reason, even if they're holding about 40% on fully conversion basis, but there is a challenge vis-a-vis their right to approach NCLT, because you're not holding equity or mandatorily convertible quasi-equity. It is just a hybrid instrument which may not get converted. So that's a practical situation, and the people may not kind of invest into OCD. Other financial services. So what they say that, in case this is an important one. They say if you are doing any business into the identified, financial activities such as banking, insurance, pension fund, So that is a one route wherein the FDI is allowed. Second is the unidentified. We call it OFS, other financial services, which got introduced in 2016. So they say if that other financial services, that activity is not regulated under by any financial regulator, or it is partly regulated, or there is no clarity about whether regulated or not, in that case it is subject to the approval route. So the classic example which I have come across 10 times, by the way, one case is pending. I'm doing a live case and we have got the in principle approval. The live case is that of the investment advisory, and sir, I think you would appreciate that investment advisory side. So under SEBI regulation, there is a clear-cut exemption saying that if you have you are an investment advisor, but the exclusive class of your customer are non-resident other than NRI, so you are exempt from SEBI investment advisor regulation. No need to come to us. SEBI clearly say no need to come to us. You are exempt category. Now think about a situation which is a live matter happening. I am floating a Indian subsidiary. That company is going to be an investment advisor, and that company is going to make services purely to the US client. No Indian, no NRI. So we went to RBI, we went to SEBI. SEBI said you are exempt. So I am a financial sector company, other financial sector company, but I am not regulated. Then we approach, Ministry of Finance, Department of Economic Affairs. They say, okay, come to us, make the application, we'll approve it. So that we got 2-3 approval in recent past. So that's a classic case that we are we are covered under kind of SEBI regulations, but still we are not regulated. So that's a case I thought to let you know. That's the process, how this application moves. I think, so this is done.